Last but not least, arbitrations can be conducted very flexibly in terms of procedure. Again, we can adapt the procedure to the particular requirements of the dispute we are looking at. So we can adjust the speed of the procedure. We've heard the term fast-track proceedings in arbitration many times before, even supersonic proceedings. We could have an arbitration in 6 weeks, 3 weeks, 2 weeks, depending on the complexity, of course, of the case and the availability of the individual judges. But the judges can be chosen again on the basis of their availability, obviously. There are the evidence rules we've just heard about. In arbitration, we could adopt a very idiosyncratic regime for the revelation of evidence, disclosure. We could have a prima facie evidence rule, which says that if the claimant proves a prima facie case against the potential infringer of competition laws, then it's up to the infringer to disprove with the relevant evidence and the evidence he most probably holds himself in his possession that he did not infringe the competition laws, failing which the arbitrator will enter an award against the particular respondent. Alternatively, there can be reversal of the burden of proof. Furthermore, there's of course the question of the role of antitrust authorities in any of these arbitrations. In commitment arbitrations, there's obviously an underlying commitment decision. So the antitrust regulator already knows that there may be an arbitration going on in relation to the correct implementation of the commitments. So it's not like the antitrust authority is in any way unaware, or that the particular parties need to be afraid of the Commission or any other antitrust regulator who has made or taken that particular commitment decision. Right to the contrary, get it right, implement correctly, and if the antitrust regulator can make a contribution to that, why not? Question mark. This again stands in marked contrast, obviously, to the procedural rigidity of courts. What about antitrust arbitration in practice? Ordinary antitrust arbitrations. Here we go. Now, you need to be aware of the fact that due to the private and confidential nature of arbitration, one cannot say for sure how many antitrust arbitrations there have been. The fact, though, that a vast number of agreements that are prone to raise competition law issues contain arbitration clauses will tell you that there must be a vast number of antitrust arbitrations out there we don't know about. You only know about these arbitrations either if the parties agree to publish extracts of the award, or if an arbitration body like the ICC, who's been very active in antitrust arbitration, has managed to strike some sort of deal with the parties by saying, okay, we anonymize certain extracts of the award, and then we are allowed to publish these particular awards in our ICC bulletin. Or, in ad hoc arbitration, the parties have agreed that the professor who was the arbitrator is allowed to publish part of the award, again anonymized, in one or the other legal journal. So we can only rely upon a very small sample of actually published material to actually piece together the puzzle. Now, that's exactly what I've tried to do, and that's what this particular sample is based on. We've got, in ordinary antitrust arbitrations, at least 55 ICC antitrust arbitrations over the period 1964 to date. They have involved alleged antitrust infringements, example is given exclusivity and non-compete provisions, in relation to distribution license agreements, exclusive long-term supply agreements, exclusive agency agreements, etc. 44 of these deal with EU competition law, including Articles 101, 102 TFEU, and even one of them deals with state aids, but obviously only questions in relation to state aids that do not fall within the prerogative, in this case, of the European Commission, namely the question as to whether there was a need for notification of a particular aid in the first place. 9 of these particular ICC arbitrations deal with domestic antitrust laws, including Czech, French, German, Hungarian, Italian, Korean, Portuguese, and Spanish competition law. 2 of these deal with US antitrust law. There are certainly a number of AAA, American Arbitration Association, DIS, being the German Institute for Arbitration, or the German Arbitration Institution, and the Swiss Chamber of Commerce antitrust arbitrations. And there are even more certainly a number of ad hoc antitrust arbitrations that have taken place outside a procedural or an institutional framework, like the ICC or the LCI, etc. What about commitment arbitrations? There are around 62 arbitration commitments in EU conditional merger clearance decisions. Now, over the period 1992 to date, remember, the merger regulation was introduced in 1989. This makes up 20% of all conditional merger clearance decisions since adoption of the merger regulation. So that's a very, very significant number, 20% out of all conditional merger clearance decisions. Around 11 arbitration commitments can be found in US consent decrees, at least 11, because this is based on research done by some American scholars in contribution to the particular work I cited at the beginning of my talk. So I didn't check that myself. I'm sure that there may well be actually double the number or treble the number because they only took a sample. Over the period 1987 to date, around 7 arbitration commitments in Canadian merger control. Again, the same applies here as to the American sample. I relied upon other people's research. I'm sure there must be multiple of these. And around 5 arbitration commitments in Article 9 commitment decisions, EU commitment decisions, under Regulation 1/2003, the EU Modernisation Regulation, over the period 2005 to date. 4 of these relating to Article 101 TFEU, 1 relating to Article 102 TFEU. There's at least 1 arbitration commitment in Swiss competition law, and around 28 arbitration commitments in EU individual exemption decisions over the period 1967 to 2000. And as I said before, this practice has now been discontinued with entry into force of the EU Modernisation Regulation. Then we have to consider that there also at some point existed certain regulatory frameworks that prescribed settlement of disputes by arbitration, such as Regulation 1400/2002 concerning motor vehicle distribution and servicing, which I think expired in March 2010. And as I mentioned previously, these statistics are just the tip of an iceberg. As I say here actually on the slide, these are a total of 170 examples where arbitration was used in one form or another. And they're literally just the proverbial tip of the antitrust arbitration iceberg, for the simple reason that A, there are loads of agreements out there which are prone to give rise to arbitration and contain arbitration clauses, prone to give rise to antitrust issues and prescribe arbitration as a dispute resolution mechanism. And B, many of these are concealed from the public because arbitration is private and confidential, and public members do not have access to any of these awards. Furthermore, there have been quite a few impressive soft law measures and initiatives, more or less recently, in promotion of antitrust arbitration. In particularly, we have the ICC, the International Chamber of Commerce, with its International Court of Arbitration in Paris, which has been extraordinarily active in the field. It established 2 consecutive working groups on this particular issue. The first one, sometime around the 1980s already, ICC Joint Working Party on Arbitration and Competition. It produced a report in 1984, ominously enough. 1984, isn't that the title of the book? George Orwell, 1984? Anyway, ominously enough, it was published in 1984. And it was approved by the executive board of the ICC at the time, so it was given a lot of credence for this reason alone. Number 2, the ICC Task Force for Arbitrating Competition Law Issues, more recent. It was established in 2003 and finally completed its mandate in 2006. It intensely discussed and debated ordinary antitrust and commitment arbitrations and produced, believe it or not, an ICC draft best practice note on the European Commission acting as amicus curiae in international arbitration proceedings and a draft report on procedural issues and arbitrating competition law issues. Now, I have to admit none of these were adopted officially, so the Executive Committee of the ICC never approved these because there was too much of a lack of consensus in between the members of the task force in relation to these particular texts. Then we have, most importantly, introduced by the Commission, the revised EU Notice on Remedies, which expressly provides for the use of arbitration access commitments, i.e. for access to key infrastructure and technology in EU motor control. And most recently, which I'm very pleased to see, the Office of Fair Trading, OFT, officially encouraged the use of arbitration for the settlement of antitrust disputes in its publication Quick Guide to Private Litigation in Competition Cases of March 2010. So what is the basis of the arbitrator's jurisdiction? Where does he get the power from to adjudicate competition law or antitrust disputes more generally? Now, two important planks, really. First of all, antitrust arbitrability. Antitrust must be arbitrable under the procedural law applicable to the arbitration proceedings, otherwise the arbitrator cannot arbitrate a competition law dispute. As I said at the beginning, criminal law, for example, is generically not arbitrable. So no matter how much you ask an arbitrator to, no much you ask me as an arbitrator, for example, to put Boris into prison, I couldn't do it. No, I'd like to put him into the rector's palace behind the bars there, but I can't. I really can't. So, certain topics are not arbitrable, certain subject matters of the law. But the good news is, antitrust arbitrability nowadays is almost globally recognized, subject to some very minor exceptions, which for present purposes are irrelevant. The second plank is the scope of the arbitration agreement. The arbitration agreement is the mandate of the arbitrator in every single particular reference.